I would request you all to please subscribe to the channel and press the bell icon for more updates on corporate and commercial laws. In the present matter, the appellant, Mr. Sushil Ansal, Director of Ansal Properties and Infrastructure Limited, has preferred this instant appeal and approached the Appellate Tribunal against the 17th March 2020 order of NCLT Bench, New Delhi, wherein the tribunal admitted an application under Section 7 of IBC filed by the respondents, Mr. Ashok Tripathi and his son, Mr. Saurabh Tripathi, claiming to be financial creditors in the capacity of decree holders against the corporate debtor on account of non-payment of amount due under the recovery certificate issued to them on 10th August 2019 by the Uttar Pradesh Real Estate Regulatory Authority. In this session, we will be covering a very pertinent precedent set by NCLAT on whether a home buyer in the capacity of a decree holder can claim himself to be a financial creditor, and if the respondent's application under Section 7 of IBC in the same capacity is maintainable. To give you a gist of the backdrop, the factual matrix, the respondents in the present appeal, Mr. Ashok and Saurabh Tripathi, booked 2 dwelling units under a real estate project named Sushant Gaul City in Lucknow. The first unit was owned by both of them jointly, and the second was booked by respondent number 2, Saurabh Tripathi. Both the parties entered into a built-up build-up-by agreement in 2014 with respect to the first unit and flat-buy agreement for the second unit. Accordingly, allotment letters were issued by Ansal Properties, who is the corporate debtor, in favor of the allottees. The corporate debtor undertook to complete the construction and delivery of possession within 2 years of the commencement of construction. However, the corporate debtor had failed to do the same within the given time frame, and even after the lapse of 5 years, construction was not completed, nor was the advance amount that was paid by the allottees refunded to them. Accordingly, respondent number 1 and 2 filed a complaint with UP RERA in 2017 and 18 respectively for a refund of money and to initiate recovery proceedings as the unit was not completed within a stipulated time. UP RERA directed for a recovery certificate on 10th August 2019 to establish the existence of financial debt and liability of the corporate debtor. The corporate debtor had agreed to refund the amount as emanating from the orders given by UP RERA, and the part payment of the decretal amount had already been made by the corporate debtor. However, respondent number 1 and 2, the allottees, who were entitled to seek disbursement of such amount from UP RERA, upon its recovery, instead filed an application under Section 7 of the Insolvency and Bankruptcy Code for initiation of corporate insolvency resolution process in the capacity of decree holders against the default of financial debt committed by the corporate debtor, which is now contested by the corporate debtor, appellants in the present case, on the ground that the same was non-maintainable, as respondent number 1 and 2 did not fall within the ambit of financial creditors as allottees of real estate, and in the case of their status being recognized as allottees. The appellate tribunal proceeded to pass an order admitting the joint application of both the respondents, which has been assailed in this appeal. It is very imperative to mention another development that took place during the pendency of this appeal, wherein a joint application was filed by both the parties for withdrawal and termination of the corporate insolvency resolution process and prayed for invocation of Rule 11 of NCLAT Rules 2016 to set aside the order of admission and termination of CIRP. Moving forward, let's review the arguments by the appellant. The appellant was of the opinion that the respondents filed an application just to harass and extort money from them. According to the appellant, the NCLT order was in conflict with 2020 amendment to IBC, prescribing a threshold limit, which is constituting either 100 allottees or 10% of the total allottees, to file an application under Section 7 of the Code. The ordinance was enforced during the pendency of the applications, and the same was necessary to observe upon compliance of the mandate. And in the view of legal position, the application under Section 7 was not maintainable. Further, the appellant contested that the NCLT's order treats the respondents as being decree holders, but even in that capacity, they could not be permitted to execute the decree and seek enforcement under the IBC mechanism. Lastly, they emphasized the fact that the dispute between corporate debtor and respondents has already been settled, and they filed a joint application for withdrawal and termination of CIRP, while COC has not been constituted till date in terms of order dated 20th March 2020. Now coming down to the submissions by the respondents were of the view that the dispute had already been settled and the allottees do not have any pending claims against the corporate debtor, and hence accordingly they wish to invoke Rule 11 of NCLAT Rules 2016 to set aside the order of admission and terminate the corporate insolvency resolution process against the corporate debtor, as the dispute had been settled prior to the constitution of the Committee of Creditors. With respect to the instant appeal, the appellate tribunal decided not to terminate the proceedings on the basis of the settlement, but to hear the proceedings on the basis of the merits of the case. Two full issues that were raised for consideration before the appellate tribunal. Number 1, whether this case is fit for invoking Rule 11 of NCLAT rules to allow the parties to settle the dispute, and number 2, whether the application filed by respondent number 1 and 2 under Section 7 of IB Code was non-maintainable. Now let's discuss the findings of the tribunal. With respect to issue 1, NCLAT acknowledged that the Committee of Creditors is permitted to seek an exit from CIRP at a pre-admission stage and the post-admission stage before the constitution of Committee of Creditors. A notable judgment of Swiss Ribbons Private Limited and others versus Union of India was cited by the Honorable Tribunal, wherein the apex court dealt with this issue in detail, which highlighted the fact that where Committee of Creditors is not yet constituted, a party can approach the NCLT directly in exercise of its inherent powers under Rule 11 of NCLAT Rules 2016 to allow or disallow an application for withdrawal or settlement, which shall further be decided after hearing all the concerned parties and considering all relevant factors on the facts of each case. The tribunal also observed that the exercise of inherent powers on the part of adjudicating authority or even by this appellate tribunal in appeal would depend on consideration of all relevant factors on peculiar facts of the case and invoked only to meet the ends of justice or prevent abuse or process of the court. The tribunal also acknowledged the fact that the interim resolution professional has received over 283 claims from creditors, other creditors, and employees, and the settlement deed between the respondents and the appellants does not take care of the interests of the claimants other than that of the respondents. Therefore, allowing for withdrawal of application on the basis of such settlement would be detrimental to the interests of other claimants, including the allottees numbering to 300, and would not be in consonance with the object of IBC and the purpose of invoking Rule 11 of NCLAT rules. Now coming to the main contention of whether the application filed under Section 7 was maintainable, that is issue 2, the tribunal pronounced that the dictum of law is loud and clear. An application for initiating CIRP against corporate debtor by allottees under real estate project is required to be filed jointly by not less than 100 of such allottees or not less than 10% of the total number of the allottees under the same real estate project. It is also clear that the application at the instance of a single allottee or by a group of allottees falling short of the prescribed threshold limit would not be maintainable, and if there are pending applications, provision has been made to meet the requisite majority to meet the threshold limit within 30 days of commencement of the amending act, failing which such application shall be deemed to be withdrawn before admission. However, a writ petition is pending before the Honorable Supreme Court challenging the amended Section 7 with respect to the allottees who have filed application prior to the date of the amendment, and hence NCLAT did not go into the merits of the threshold. Secondly, respondent number 1 and 2 approached NCLT not in the purported capacity of allottees of real estate project, which brings them within the fold of financial creditors, but claiming to be decree holders against financial debt which owed its genesis to the recovery certificate issued by UP RERA. The question before NCLAT is whether in the projected capacity as decree holders they could maintain an application under Section 7 of IBC. The appellate tribunal observed that the contention of coming within the purview of financial creditors rests on the strength of the definition of creditors in terms of Section 3, subsection 10 of IBC, which includes a decree holder within its fold. However, the pressing issue here is even though a decree holder is covered by the definition of creditor, it does not fall within the definition of financial creditor across the ambit of Sections 5, subsection 7 of the IB Code, which means to include any person to whom a financial debt is due, and assignees and transferee of financial debt are also covered under the definition of a financial creditor. However, NCLAT observed that the nature of debts styled as financial debt within the ambit of Section 5, subsection 8 of IBC is also relevant to a certain, and subclause F of subsection 8 of Section 5 provides that any amount raised under any transaction, including any forward sale or purchase agreement having a commercial effect of borrowing, would fall within the ambit of financial debt, An explanation it provides that any amount raised from the allottees under a real estate project shall be deemed to have a commercial effect of a borrowing. NCLAT observed that a transaction in question has the contours of borrowing as contemplated under Section 5 of IBC. However, the case set up by the respondents before the adjudicating authority is not with the status of financial creditors having the commercial effect of borrowing, but on the strength of the decree holders. With the provisions of law, NCLAT came to a conclusion that a decree holder would not fall under the definition of financial creditors, as the amount claimed under the decree is an adjudicated amount and not the debt disbursed against a consideration for a time value of money, and does not fall within the ambit of any clauses enumerated under Section 5, subsection 8 of IBC. The court also discussed another important aspect of law as to whether the execution of decree on the strength of recovery certificate issued by UP-RERA would justify triggering the CIRP at the instance of respondent number 1 and 2. The appellate tribunal, while considering this question, took reliance of a recent judgment, G. S.Y. Rao versus Stress Asset Stabilization Fund and others, wherein it was held that application under Section 7 of IBC cannot be filed for execution of decree, and in such case it will be covered by Section 65 of the IB Code, which stipulates that the insolvency resolution process or liquidation proceedings, if filed fraudulently or with malicious intent for any purpose other than that of the resolution of insolvency or liquidation, attracts penal action. And NCLAT in this view held that the application under Section 7 of IBC was not maintainable in their projected capacity as decree holders. After discussing the findings of NCLAT in detail, the tribunal in its final verdict held, number 1, that the application for triggering CIRP is not maintainable as decree holders. Number 2, the decree holders, even though included in the definition of creditor, does not fall within the definition of financial creditor and cannot seek initiation of CIRP as financial creditors. And accordingly, NCLAT set aside the 17th March NCLT order, which suffered from grave legal infirmity, paving a clear distinction between a creditor and a financial creditor and setting a blanket provision that the purpose of IBC is not enforcement of decree or adjudication of decree. The tribunal also defined that the purpose of the judgment is to safeguard the process against fraud by people who are wrongly seeking recovery of the RERA certificate.